Good morning.
Good morning.
The state in this case is required to prove all the elements of the indicted offenses beyond a reasonable doubt. The judge told you that. That's our obligation. We're happy to accept it. And in this case, we think we prove each and every element of each and every count beyond a reasonable doubt, and we will be asking you to find the defendant guilty of all counts when you retire to consider your verdict. In going over each of these counts, I'll start at the end of the indictment, with counts 6 and 7. The defendant is charged with possession of a Schedule 4 controlled substance with the intent to sell and deliver. That's counts 6 and 7. The Schedule 4 controlled substance is prazolam, referring you to Exhibit 33, the 10 pills that were identified and taken out of the defendant's pocket upon his arrest after shooting the victims in this case. 10 pills. The testimony of Mark Dunlap at the TBI lab that he examined those pills, Exhibit 37. They were 10 tablets. They are prazolam. That is a Schedule 4 controlled substance. All the evidence in this case, including the defendant's testimony, establishes that the defendant brought those pills to the Campbell County School, which is in Campbell County. Did so with the intent to sell and deliver. The delivery is proved by the statements of the defendant and by Trent McCullough that he had the pills, he crushed them out, he delivered the 3 lines. He took a line, the others were there for the other people. Those counts are proved, and I don't believe they're really contested by the defendant, at least not in his testimony. So he asked you to convict on those counts. Count number 5, the unlawful carrying a weapon on school property. In order for you to convict of that charge, we must show that the defendant carried a weapon on the school property, and the proof is undisputed as to that fact. This is the weapon that was identified by all the parties that were available to it. You remember the testimony of Steve Scott that it is in fact a working weapon, that it can be fired if all the functions operate correctly. The defendant admits that he took the weapon to the school. This is the weapon that he used to kill Kim Bruce and to shoot Jim Pierce and Gary Seal. Count number 5, we have proven beyond a reasonable doubt. We ask you to convict of that count. The remaining counts, counts 1, 2, 3, and 4, are separate accounts, and the court will instruct you that you must make your decision as to each count individually. But all 4 of those counts share common elements. Counts 1 and 2 deal with the killing of Kim Bruce. Count 1 is charges the defendant with the premeditated killing of Kim Bruce. Count number 2 charges the defendant with the first-degree murder, the unlawful killing of Kim Bruce during the attempt to kill Gary Seal or Jim Pierce. It's called felony murder. What all of these counts share in common is the culpable mental state. What the state has to prove is that these killings were intentional and with premeditation. So I want to spend a little time talking to you about premeditation and intent. Intent in this case, and the judge will instruct you, means the actual intent to kill the intended victim, cause the death of someone. And we think the proof shows this. In count number, and that's the same intent for counts 1 and 2 and 3 and 4. The actual intent to cause the death of someone. In counts 1 and 2, the intent is to kill Kim Bruce. In count 3 and 4, the intent required is the intent to kill Jim Pierce, and in count 4, Gary Seal. Even those are attempts. They are not completed crimes, only attempts. But the intent is the same. And the other element we have to prove is premeditation. The judge will instruct you what premeditation is, and you'll have that charge with you in the background and in your jury room. And it talks about premeditation is an act done with premeditation is an act done after reflection and judgment. And those are good words. But I found a more easily working definition of premeditation to be this. Premeditation is the process of thinking about a proposed killing before engaging in a homicidal conduct. State versus Brown. That's the way to think of it. You must follow the jury instruction. You must determine that the defendant acted after the exercise of reflection and judgment. This is a helpful way of looking at what exercise of reflection and judgment means. The process of thinking about a proposed killing before engaging in homicidal conduct. And this very same case gives you examples of factors you can look at to determine what might constitute premeditation. And one of those factors is the use of a deadly weapon on an unarmed victim, the particular cruelty of the killing, declarations by the defendant of intent to kill, evidence of procurement of a weapon, preparations before the killing for concealment of the crime, and calmness immediately after the killing. There are other factors that you can look at, but those are suggested factors as set forth in this case, and factors you're allowed to look at. You also look at your common sense. You must always keep that with you at all times. The experience that you have had as an individual growing up and living your life. You're allowed to apply that to situation, and you should never let that go. The other element that we have to prove in counts 1 and 2 is the unlawful killing of Ken Bruce. This proof, I think, is undisputed, according to the evidence. There isn't any question that the defendant, Kenneth Bartley, killed Ken Bruce. There isn't any question that it was unlawful. And by unlawful, all that means is he had no legal justification or excuse for killing Ken Bruce. That's an element we have to prove. And there's no dispute about the facts in that case, or at least I don't think so. There's certainly no dispute in the evidence. The defendant unlawfully killed Ken Bruce, and that applies to counts 1 and 2, premeditated murder, felony murder. Now we get into conduct of the defendant to show proof of a premeditated intent to kill. And we'll go through these factors, and we'll show you that this is the evidence that came in, either through the state or the defense. Factor number 1, the defendant hunted for the gun. He took steps to procure a weapon. And you recall his testimony, that I was looking for the gun. I went to my father's bedroom. I found the gun in his chest of drawers. Conduct. He decided to hunt for the gun. Put ammunition in the magazine. He decided to load the magazine. You recall his testimony. Well, I found the bullets and I just loaded the bullets into the magazine. That too is a decision that the defendant made in the course of this event. The next is put gun in pocket. That was a decision that he said. He decided to put the gun into his pocket. He put the magazine into his pocket. That's from the state's proof and from the defendant's proof. All of these indicators here are all conscious decisions requiring reflection and exercise of judgment by the defendant. It doesn't require planning. It doesn't require deep writing out scenarios and things like that. Just conscious decisions to take certain steps. Conscious decisions that create the process of thinking about a killing before engaging in the homicidal conduct. What other steps does the defendant take to commit a premeditated intentional killing? He picked out cargo pants to wear. He chose those pants to wear. What is the purpose of that? Those cargo pants have large pockets. He could conceal. He can conceal this weapon, Exhibit 32, in the large pockets where it would not be readily available and visible to outsiders. That was a conscious decision on his part. He concealed the gun on his person. He put it in the pocket and kept it there. All that is a conscious decision on his part. Reflection and judgment. I have the gun, I'll put it in my pocket. The next conscious decision he took was he took both the gun and the ammunition to Campbell County High School, and he did so late in the day. You recall his testimony about I was feeling sick or didn't want to go. I stayed late at home. I searched for the drugs. I searched for the gun. I went to school late. I took the gun and the ammunition to school. All conscious decisions on the part of the defendant, leading up to the end result of the death of Kim Bruce and the wounding of Jim Pierce and Gary Seal. You remember his testimony and Preston Young's testimony that they discovered the gun on his person, bumping into him, touching him, talking about it. Discovered this gun in his pocket. And the defendant told them not to tell. Don't tell anybody. A step of concealment of the crime before it occurred. This came about also in Exhibit 45. It's evidence in Exhibit 45, the intake sheet at the hospital, the information he gave them. And if you recall, was talked about several times, is that the defendant stated that some kids asked to see the gun and he realized he had been told on. At that point, he knew that other people knew about the gun. He knew Preston and Daniel had it. He asked them not to tell. He didn't think they would tell. That's a reasonable inference from the evidence. In fact, they did tell, didn't they? Kids saw that he had the gun and he realized he had been told on. The next event is that he's in his classroom. When Susan Phillips, the SRO, comes to get him off, he makes a conscious decision not to surrender the gun to Susan Phillips, who he describes as a law enforcement officer, because she wore the tactical pants, the cargo pants, and had a polo. But he made the conscious decision. And you remember his testimony. Well, I thought it was about my tardiness, so I didn't think they knew. I thought I'd be okay. Conscious decision not to surrender the gun. Later on his way to the office, you remember he stopped outside the front window of the office and went over the sign-in sheet. That was our first exhibit, I believe, in this case. Went over that with Susan Phillips and discussed his tardiness. Mr. Pierce came and brought them back into his office. And on their way there, remember the defendant's testimony. On the way there, Mr. Pierce had come out to the door to bring them back, and you saw that in the video. And on their way there, the defendant said, I saw Preston Young and Daniel Hammond leaving over here. Now, what he said was, I didn't put two and two together, but that's not a reasonable response from him in this case. He knew he had the gun. He knew he had the drugs. He also knew he was tardy. He knew Preston and Daniel, both of them, knew he had the gun. It's a reasonable inference. In fact, it's almost inescapable that the defendant at this point knew he was going back to Mr. Pierce's office and that Daniel and Preston had told. The importance of that and the importance of Exhibit 45, that other kids knew and had told on him. The importance of that is, when the events unfold in Mr. Pierce's office, the defendant's not surprised. He's not surprised. He's not shocked. It's not a sudden event that causes him to react in some kind of altered state. He knows. He knows other people know. He knows what he's done and doing. He sees Daniel and Preston, and he knows, I'm in for it. And yet, he doesn't surrender the gun to Mr. Pierce and Miss Phillips while they're sitting there chit-chatting in a friendly way. Conscious decision. He's still running out the string. I thought it was about tardiness. Now I kind of know it's about something else. Might be about something else. But I'm not sure. May not be caught. I'm not going to give it up. This is a conscious decision on his part. Exercise, reflection, and judgment. Not give the gun up. Mr. Seal and Mr. Bruce arrive, and he doesn't surrender the gun when he's asked to. You recall the testimony. Mr. Seal arrives and goes and sits next to the wall. And the defendant is in the chair next to the door. Mr. Bruce is standing there at the door. Mr. Pierce leans up and says, "Kenny, we need what's in your pocket." He doesn't give it to him. At any time. A conscious decision on his part. A decision based on the exercise of reflection and judgment. And one factor to always consider in this, the law doesn't say that the exercise of reflection and judgment has to be good judgment. Every decision he's made, and he's told you he's made lots of bad decisions, and every decision he's made on this date that led to the death of Ken Bruce and the wounding of Jim Pierce and Gary Seal were bad decisions. They don't have to be good decisions. They don't have to be well thought out decisions. They just have to be conscious decisions. The exercise of reflection and judgment. And here, Kenny, we need what's in your pocket. He doesn't surrender it. And in fact, he takes steps to make sure they can't get it. We need what's in your pocket. And you recall the testimony of Mr. Seal and the defendant. Mr. Seal, the defendant reaches into his pocket, and Mr. Seal is trying to get the gun himself, reaching down there, whatever it is he's trying to get. Mr. Seal doesn't know exactly what it is, but he's trying to stop it. The defendant slaps his hand away. That's not an involuntary motion. That's not a motion of panic. That's a conscious decision on his part. Slap his hand away. He pulls the gun from his pocket. That's a conscious decision. He could have slapped his hand away and put up his hands. All right, okay, this is it. But no, he doesn't do that. He slaps his hand away and pulls the gun from his pocket. And the testimony of Seal and Bruce and Pierce, I'm sorry, not Mr. Bruce, Seal and Pierce, points the gun at all three of them. He gets up. He's waving the gun around. He's pointing at all of them. Remember Mr. Seal? I kind of leaned back. You remember Mr. Pierce's testimony? I'm kind of looking at it, don't know what to do. Mr. Seal testifies, Mr. Bruce, that he walks Mr. Bruce back. Mr. Bruce has got his hands up. The defendant walks him to the back of the room. Walks Mr. Bruce, Exhibit 12, walks Mr. Bruce to the back of the room, positions himself somewhere here. Now Mr. Bruce has got no place to go at this point. He's gotten as far away as he can get. He's trapped in this corner. The defendant with a gun is between him and the door. It's not the defendant that's trapped. It's Mr. Bruce that's trapped. It's Mr. Pierce that's trapped. It's Gary Seal that's trapped, not the defendant. So we walked him in to the back of this corner. And another decision he makes, after he walks Mr. Bruce back to the back of the corner, back of the room, Mr. Seal is here, and Mr. Pierce is at his desk. What does the defendant do? He comes back here too. And what is this right here referring to Exhibit 12? That's a door. The door he could open. And he testified, you can get two ways into the main central office there at the school. You can go out the way he came, or go out the other way. What's the importance of that? Referring to Exhibit 4, all he had to do was go out on the hallway, exit the school, and run away. If he was worried about getting caught with a gun, all he had to do was run away. He wasn't backed in the corner. Mr. Bruce was backed in the corner. No one was holding a gun on him. He was holding a gun on other people. All he had to do was run out the office, ran out the door. There wasn't a soul that could stop him. He had the gun. There wasn't a gun in the school except for this. You heard the testimony of Susan Phillips. She's not armed. She was the only SRO there. Teachers aren't armed. He was in control. He's not afraid. He's not panicked. He's in control. All he had to do was run away. He chose not to. It's a conscious decision. A decision reflecting exercise of reflection and judgment. So he's walked Mr. Bruce to the corner and got him stuck there. And he's got his hands up Mr. Bruce does. And ask yourself this. At this moment, who's really closer to panic? The defendant with the gun, or Mr. Bruce and Mr. Seal and Mr. Pierce? Who is it more reasonable to be in the fearful situation? The shooter, the killer, or the victims? The defense has tried to portray the victim in this case, the defendant in this case, as a victim. That somehow or other these school officials cornered him and confronted him and demanded things of him and made him fearful, when all they really did was try to isolate him from other students and take a loaded gun from him. The defendants walk past the door. He doesn't run away. He goes back into the office. And Gary Seal says, "Is that real?" And the defendant says, "Yes, it's real. I'll show you. I never liked you anyway." That's important because it is declarations by the defendant of intent to kill. I'll show you it's real. I intend to use it. I never liked you anyway, talking to Mr. Seal. I'm going to use it on you. That's important because that proves count 2, the felony murder. That the defendant, after the exercise of reflection and judgment, intended to kill Gary Seal. Yes, it's real. I'll show you. I never liked you anyway. I'm going to use the gun on you. And he does. He shoots. I shot again. And that's the intent that we have to show in count 2. Not that in count 2, mind you, not that he intended to kill Ken Bruce at this time. He intended to kill Gary Seal, and in the process of attempting to do that, he killed Ken Bruce. That's count 2 there. The testimony of Gary Seal and Jim Pierce. He reaches into his pocket and retrieves the clip, the gun